Good afternoon, everyone. My name is Michelle Storms. I'm the Executive Director of the ACLU of Washington. I use she, her pronouns, and I'm actually here in our office today, here in downtown Seattle. Our office actually sits on the lands of the Coast Salish people, particularly the unceded territory of the Duwamish people. It's critical that we both acknowledge the land we're on and acknowledge we still owe the people whose land we are on. The tragic, uncalled for, and illegal losses to Indigenous people have been extreme and are an issue we must address as a nation and as lawyers. We have work to do to make this country fair and just and to bring justice to Indigenous people. We have an amazing CLE to share with you today, and I have a lot of introductory comments to make, but I want you to know that we will have plenty of time for your questions at the end, so please be thinking about what you want to ask us as we go along. So at the ACLU of Washington, we've been hosting this series of CLE sessions on race equity in our work and in the justice system, because we know that we're far from racial equity in our society, and certainly we have not achieved it in our legal system and our courts. So if you attended part one of this series, you heard Twyla Carter break down the history of our country and our laws, with particular highlights on racial discrimination and inequity, everything from slavery to Jim Crow to mass incarceration to redlining and on and on. From there, in part two, we journeyed into the practice of amicus briefs and how those friend of the court briefs present a powerful opportunity to raise the contextual societal issues such as race equity using social science studies and strategic legal arguments on a variety of cases to get us closer to the just system that we all deserve. So today is our third and final CLE, and we're going to take a look at litigation, at the cases that give us the opportunities to address racial injustice. So I'm first going to introduce the panelists, then I have a couple more comments very briefly, and then we're going to get right into it. So really excited to have David Perez today. He's a partner with Perkins Coie and is a trial attorney focused on intellectual property, real estate, class action, constitutional law, and employment. He's also the firm-wide chair of the business litigation practice. We also have Bree Blackhorse, who's an associate with the Native American Practice Group at Kilpatrick Townsend and Stockton LLP in Seattle. Bree is an enrolled member of the Seminole Nation of Oklahoma and serves as an associate at the firm that I mentioned. She advises tribal governments and enterprises on all aspects of federal, state, and tribal law, including tribal sovereignty, economic development, treaty rights, and complex Indian country litigation. Bree has previously been a public defender, a legal aid attorney for the Yakama Nation, and an associate at the firm of Galanda Broadman. And formerly also a law clerk to the Honorable Brian M. Morris in the U.S. District Court for the District of Montana. Bree is currently the chair of the ACLU Washington Legal Committee, and we're so glad she is. We also have Toby J Marshall today, who's a member of the Terrell Marshall Law Group. He's a founding member of that group, and he represents plaintiffs in class actions, collective actions, and other complex litigation involving wage and hour, consumer protection, and civil rights issues. He has tried and won cases in state and federal courts, and also briefed and argued cases before the Washington State Supreme Court, Washington Court of Appeals, Ninth Circuit Court of Appeals. Toby graduated from the University of Washington School of Law and has been named several times to the super lawyers list in Washington Law and Policy. Last but absolutely not least on our panel today is Jennifer K Chung, an associate with Davis Wright Tremaine. Jennifer is a commercial litigator who concentrates her practice on intellectual property disputes and matters involving technology issues. She's a member also of the ACLU Washington Legal Committee and maintains an active pro bono practice working on civil rights and immigration matters. Okay, that is our esteemed panel. I guarantee you we're going to have an amazing conversation today. But I have two more things before we get started. First, I just want to put it out there right now. These folks, Jennifer, Toby, and Bree have all been, and David, have all been cooperating attorneys with us, and we're looking for new cooperating attorneys all the time. We've long worked with volunteer cooperating attorneys to help protect and promote civil liberties throughout the state. The work available at any given time for volunteer cooperating attorneys varies quite a bit, but it can include everything from trial level and appellate litigation, policy advocacy, research and consulting projects, legislation, ordinance issues, speaking at CLEs and Know Your Rights events, helping to draft publications, and so much more. If you're interested, there's an application on our website, and the link is going to go into the chat right about now. The second preliminary matter I have is I really want to thank all of the ACLU staff who have helped to get this CLE off the ground. Elizabeth Jarvie, Tony Davis, Nancy Tallner are all here with us and have done so much work envisioning this series. But I also have a special presentation. So last month, you heard from one of our senior staff attorneys, Nancy Tallner, about our amicus work. What is amazing is that Nancy has been with our organization for 26 years. Being in this virtual space, we've not been able to celebrate her as vigorously as we want to with cake and balloons. But since this summer has not yet allowed us to be in person together, we're going to take a few minutes out of this CLE to give her a tribute, much I'm sure to her consternation. Nancy's contributions over the past 26 years are innumerable and legendary. When she started working here, she was the only attorney, which meant she was an integral part of building the legal litigation program from the ground up, helping to set our standards, strategic priorities, and beginning the building of an outstanding reputation for strong, zealous advocacy at the ACLU of Washington to uphold and expand the civil liberties and civil rights of people in Washington state. What some people may not know, before becoming a staff attorney with the ACLU of Washington, Nancy was also a cooperating attorney. So her investment in this work exceeds 26 years, which is equally astonishing. There are too many examples to name, but I'm going to talk about three things very briefly. First, her work to abolish the death penalty in this state. Most of you know that in 2018, our state Supreme Court found the death penalty unconstitutional due to the racial disparities inherent in the process. What many do not know is that it was in large part due to Nancy's brilliant engineering that the pathway toward building the case that would ultimately get us to this victory began as early as 2001, if not earlier. At that time, the ACLU of Washington was analyzing all the reported capital cases in Washington to evaluate how well our state guarantees constitutional fairness in death penalty trials and laying a groundwork for the many challenges to come. The victory was decades in the making, and Nancy was there at the start of it. Second, let me say something more about the amicus work. Under Nancy's direction, the ACLU of Washington has become a powerful voice through the presentation of amicus briefs. Nancy understood early on that as important as our actual litigation is to enforcing the civil liberties of Washingtonians, that we could have an even greater impact on the law in the state through amicus practice. Now, amicus cases, as you likely know, are ones where the ACLU is not a party to the litigation, but where we think the case presents important issues and we have something to say that would assist the court in making the right decision. We watch cases in the Washington appellate courts, especially the Washington Supreme Court, looking for cases that involve important civil rights and civil liberties issues, with a careful eye on ones that have an impact on race equity. Substantively, these cases run the gamut from criminal procedure to immigration, free speech, even family and child welfare law, any cases where there's a civil liberties issue at stake and where we can potentially make a difference. Okay, the third thing I want to say, I'm just going to call this Encyclopedia Britannica, because everyone on our staff, and quite likely many attorneys in the community, know that if you have a question about civil rights or civil liberties ruling or principle in Washington or practically anywhere, just ask Nancy. You'll get an answer immediately. And if it's not an immediate answer, you can rest assured it is in one of her famous files. Nancy voraciously consumes the advance sheets and stays constantly abreast of what is happening in the law. Then everything she reads just seems to live in her head. The bright line rules, along with the nuances and complexities that make our work to change systems for the better of all, both challenging and rewarding. I personally feel so honored, so lucky to have known and gotten to work with Nancy for many years. So I want to turn it over to our legal committee chair and one of our panelists today, Bree Blackhorse, who would like to come to make a brief presentation as well, and then we'll move on to the CLE proper.
Nancy, on behalf of ACLU Washington and the legal committee, where I first came to know you and now as a cooperating attorney, we would like to present you with this gift to honor your 26 years of service. This is a hand-printed seriograph by Coast Salish artist Peter Boom. Peter is an enrolled member of the Upper Skagit Indian Tribe, an attorney and member of the ACLU Washington. And this piece is titled Visionary, and it depicts a lone wolf as it bravely strikes out to find new territory and grow its pack. You are a legal visionary. You've bravely sought to protect and advance our civil liberties for decades and also fight for racial justice. For all that time you've worked for ACLU and served our community, you have grown our civil liberties and racial justice packs by mentoring generations of attorneys and ensuring our legal system is just and equitable for all people. So thank you for your 26 years of visionary service.
Well, I'm speechless, and thank you. I mean, I can't say thank you enough. That is just absolutely beautiful. Thank you so much.
Well, Nancy, we thank you so much. We are just grateful, 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 and keep bringing what you bring. And I hope you've had a chance to see a little bit of what's in the chat, because it is pretty much a nonstop cheer fest. So we're going to try to save that for you so you can look at it later, but thank you. And I guess the other thing I would say is this CLE series was in part your brainchild as well. So we just have lots of things that we're feeling good about. Oh, you're shaking your head no, but you know, it was. So, okay, so now I'm just gonna get right into it and start the actual CLE. And staff members, if you wanna step off camera, you're welcome to do so. But thank you so much, everyone, for participating, and thank you, Bree. Okay. So to our panelists, all of you here have been working on cases with a significant race equity element. So I'd like to get into the details of some of these cases, why they're important, why you chose the approaches and the arguments you've used. So I'm going to start with David. Are you ready, David? Okay. You've taken on one of the more difficult and controversial issues these days, specifically addressing inequities in policing and the right to protest police violence itself. Please tell us about the BLM versus Seattle case, the Black Lives Matter versus Seattle case. What is the case, the legal basis for it, and why was it important to bring that case?
Sure. So taking a step back, I mean, I think we all sort of remember late May, June of 2020, which was a really kind of a raucous time in the country, but also in Seattle, specifically in Portland and in many other municipalities around the country. You know, widespread protests broke out against police brutality. And in some jurisdictions, some municipalities, Seattle in particular, these protests against police brutality were met with yet more police brutality, and sometimes just almost comical amounts of violence that was state sanctioned from the police department. And night after night, we saw this on the news, we saw it in the papers, we saw it in social media, where the police were reacting in these just over the top. It was almost like a caricature of what a police force ought to do to its own citizens. And it looked like a war zone, and specifically in Seattle, but it wasn't just Seattle, but specifically in Seattle, we saw night in and night out protests in Capitol Hill in particular, but other neighborhoods being met with tear gas, blast. You'll hear my son in the background, and tear gas is a weapon of war. I mean, this is not, you know, a local law enforcement tool. This is what armies use. This is what soldiers use. But in Seattle, we saw the police force using it against their own citizens. And one of the kickers for me was when we saw the city impose a curfew. And not because of COVID, not because of safety or health, but because they wanted to curtail the protests even more. And now they wanted to say, you can't come out after 5. And I believe that happened on a Wednesday of that first week of June. And Thursday, we saw more tear gas against protesters. And finally, I texted Professor Robert Chang at the Korematsu Center, who I've worked with for well over a decade, and Nancy and I have worked with the Korematsu Center on amicus briefs on a variety of issues over a decade. And Nancy, you've been great, and I've worked with you now for what, 12 years, and well deserved, Nancy. And I hope to work with you for another 25, so stick around. But I said we ought to do something about this. This was a text message to Bob Chang, and that was Friday. And he said, I don't know what we can do. Let me think about it. And on Saturday, he responded back, okay, I'm in. Let's do something. And that's when I emailed Nancy and her team at the ACLU. And I said, hey, guys, we ought to do something about this. It was very simple. Like, I think we ought to do something about this. The mayor had just said the night before they weren't going to use tear gas, and then they reneged on that promise and used tear gas again. That's when I knew these representations meant nothing. They're not, their word means nothing. What we need something that's enforceable. We need something that is hard. We needed an order from a court to stop the city from doing this. So on Saturday, the ACLU immediately responded. On Sunday at 11 a.m., we had an all hands call with Perkins Coie. I had reached out to 8 attorneys at Perkins. 7 responded within, I want to say, 5 minutes. 11 a.m., we had a call, ACLU, Korematsu Center, and Perkins Coie. On Monday, we had a draft complaint. And on Tuesday, we filed the TRO. On Friday, we had a hearing. And on Friday noon, we had an order. You know, it moved quickly. But to your question, Michelle, why it's so important, I mean, I couldn't think of a more critically important message that we could be making at that moment in our history. This was just an inflection point for the country. In my view, and I think Nancy would probably share this, but I'd be curious of her view on this. I think the sheer amount of violence was because of the message. It wasn't because of broken windows. It wasn't because of some, knucklehead, lighting a fire here and there. There were very few knuckleheads. This was, in my view, an attack on the First Amendment. They didn't like the message of police accountability, a message that is sorely needed in this country. And they met that message with violence. And that is so offensive to just everything we stand for. It's offensive to what the police stand for, which is the rule of law. And we ultimately needed a federal judge applying the rule of law to finally, curb these excesses. I don't know if you want me to keep going. I know that was a lot.
That was a lot, but but it was a good lot. And I really thank you for bringing us back into the context of that moment, because it was intense.
Yeah.
It was an incredible time. There was a lot of tumult, both on the streets, but also just sort of at the policy level, at the city level, like, as you said, one direction one day, the next day, a different direction.
Right.
I don't want to speak to the obvious, but you called out the First Amendment issue, and you're exactly right. The message was police need to be held accountable, and it seemed like there was an incredibly oversized response to that. But if you could talk more specifically about the role that race equity played in the development of your facts and legal theories, that would be really helpful to hear.
Yeah, absolutely. And from tip-off, from the get-go, we knew that this was a race equity issue. And throughout society and throughout the legal community, there's all sorts of race equity problems. There's a menu of items that any lawyer can look at and pluck off and say, this is a race equity issue, whether it's youth incarceration or, the Black Lives Matter message. But police accountability in particular is a very unique issue that's just, it's not just the third rail of race equity. I mean, it has so many interconnections, police accountability when it comes to how they treat students of color. A schoolyard fight between 2 Black boys is an opportunity to arrest someone. Between 2 white students is an opportunity for a lecture. And that's the difference there is dramatic. The police accountability when it comes to traffic stops, when it comes to searches, when it comes to violence. And it's not the first 1983 case I've done adverse to a police department, how they treat, someone, pulled over, But this message was just so overdue, and you saw crowds coming out, in an emotional display of really patriotism. Our country stands for something much greater than this, and the way the police have been treating us is wrong. That message, which is at the core of so many of the race equity issues we've been fighting for decades, had to be expressed in the way it was being expressed, which is emotionally, which was loud, which was night after night. It doesn't have to be expressed with violence, doesn't have to be expressed with property damage, but it had to be expressed. And it was also bringing people together. And instead of, allowing that message to be expressed, the police wanted to drown it out in a cloud of tear gas and an array of rubber bullets. And, from our firm perspective, it was right in line with our, commitments to race equity and our commitments to diversity. So from day one, I had no resource constraints. The firm was whatever you need, however much you need, and it's continued to this day because of that underlying race equity current to it. And that's not the case with every pro bono case. There are resource constraints. There has not been one for this case.
That's really.
And let me just say
go ahead.
one other thing. The judge knew this too. I mean, Judge Jones's order on the TRO, and he gave both sides, a hard time at the hearing. He asked really tough questions. Judge Jones is a really good judge, but he began his order with an observation. He began the hearing with an observation that we are at a unique inflection point in our country, and it would be absurd for the court not to openly acknowledge that. This is not your normal protest litigation. Look what's going on in Wisconsin and DC and Denver and Portland, San Francisco. This is not unique to Seattle, and for a federal judge not to pick up the paper and know what's going on would just be a dereliction of duty. And he opened his order, and I'd encourage folks to read his order. It was very eloquent, it was very poetic, and it was legally sound.
I'm really glad you called that last part out. And later in our conversation today, we'll talk a little bit about the justice system writ large and the roles different, of us play, judges, lawyers, and so on. But what you're describing is an example of a judge naming, right, what's happening. And so often historically in law, in our cases, things are left unnamed, when in reality, what is happening is a racial disparity or race equity, apart obviously from cases where that's like the complaint or the allegations. But in so many of the cases in our history, it really is that. It's about race, it's about exclusion. So I really appreciate you calling that out. Jennifer, I want to turn to you at this time, because you also worked on a case where racial discrimination was front and center in the practices that were happening. And this is in the case where the Customs and Border Patrol were asking only certain people for identifying information on Greyhound buses over at the Spokane Transit Center. Could you please tell us about that case?
Yeah, happy to do so. So there was kind of a very disturbingly frequent occurrence pattern going on in Spokane at the time. It started in about November 2016 and then kind of ramped up. And so what happens is there's a Spokane Intermodal Center there, which is a big transport depot. There's some bus lines that go through. It's the main Greyhound bus station. There's also trains. And that's kind of a center point where folks who are coming in, going westbound from Montana and Idaho will pass through Spokane, on their way out to Seattle and Portland. And then people in Seattle and Portland pass through that center in order to get, out to the east side. And so we actually, I worked on actually a pair of cases representing Greyhound passengers who had been subject to what Border Patrol called transportation checks, which is a phenomenon where an armed, uniformed pair of patrol agents walk onto a Greyhound bus, take a look around, single out certain people, go over there and interrogate them, detain them. One of our clients was forced off the bus in very cold winter conditions and stood outside while they called the dispatcher to confirm the work authorization form that he had showed them and confirmed that things were fine. But because of his skin color, his appearance, his foreign sounding name, they said, oh, these things get faked all the time. Another client was transitioning through Spokane. He came in from Montana, was on his way to his second bus when he was approached by Border Patrol agents, taken outside. He was the only brown-skinned person there. He was interrogated. Again, they called in dispatch and should have been able to let him go, but instead decided to haul him out to a station an hour away, then leave him there for a little while, then said, okay, you can go back now. And by the time he got back to the station, all the buses had stopped running. So he was stranded in Spokane, and his wife came out from Western Washington to go pick him up. And this is an issue that was gaining a lot of attention in Spokane because people were upset that this sort of discrimination was happening in their town, their neighborhood, and that it was something that was difficult to deal with because you have the power of the federal government here that's actually engaging in these terrible acts, this terrorizing of people who don't look white, so we ended up bringing these lawsuits against the United States under the Federal Torts Claims Act. We brought torts based on anti-discrimination, false arrest, false imprisonment, so that we could, try to make our clients at least try to get them whole. And so, we worked on a team that actually had folks from Davis Wright Tremaine, as well as ACLU of Washington and attorneys from Northwest Immigrant Rights Project. So it was a lot of diverse perspectives, a really kind of a big team that worked well together, and were able to come to a successful resolution of the cases.
Thank you, Jennifer. Really powerful case. And I remember we had an event in Spokane talking about immigration issues, and people came up and talked to us afterwards who had been on various Greyhound buses. And I remember one woman was telling me that, as you mentioned before, the armed people coming on the buses, she said they came on with a German Shepherd, and they were blocking your ability to get off the bus. And she was a white woman, and she said she knew they weren't coming for her, but she was terrified. And I believe also one of the clients in that case too had actually said, I have rights or something like that. And that maybe got him in even more hot water. So it's just pretty amazing. How would you describe the systemic racial issues in your case that had a broad impact on what was happening in this situation?
Well, there was certainly a lot of targeting, right? So, conveniently, right? It just turns out that the reasonable suspicion and probable cause always somehow only turn to people who are brown. And this wasn't just something that was going on in Spokane, although it was certainly going on in Spokane. It was going on all over the country on all these Greyhound buses, going on in Florida, going on in California, just a lot of news media nationally about it. And I think recognizing that this was discrimination, that this was Border Patrol agents terrorizing people for fun, was something that kind of, I think it like the fact that this even was allowed to happen, and that it was allowed to happen so systematically, so frequently. I mean, doing transportation checks multiple times a day, every day, for a period of, I think, maybe 3 or 4 years. It's just, I mean, this is the type of, this is the kind of, the fact that our country is built on white people coming in, enslaving Black people, committing genocide on Indigenous people, kind of like, that's part of our national fabric. And it just reflected in our government, especially that government, in terms of how it manifested and how the agents actually behaved and who they picked and who they didn't,
Thank you so much. We'll come back to that. Oh, and I see there's a question later about that popped up. We'll come back to that later, how the case was resolved, because that's a good story too. But for now, let me just turn to Toby. So you've been a cooperating attorney with the ACLU of Washington over many years, but most recently you were involved in some pretty important litigation in Pierce County related to legal financial obligations, also known as LFOs. So I'd love for you to talk about that case, what it was.
Yes, thanks, Michelle. As many people watching this, I'm sure know, Legal financial obligations, or LFOs, are the fines and the fees, the costs, the restitution that courts impose as part of sentencing for criminal convictions. And this includes convictions at every level, including low-level misdemeanors. And in 2018, the average amount of LFOs imposed per case in Washington, including misdemeanor cases, was over $1,000. It was over $1,100 actually. And until these LFOs are paid in full, a person's criminal case remains open, and all of the collateral consequences that go with that and are attendant to that will follow that person around. And Pierce County, like many of the jurisdictions in the state, has a practice where it sends people who don't pay their LFOs to private collection agencies. And when it does this, the county automatically adds a collection fee of between 18 and 23%. And state law actually allows, I believe, up to 50%. So there's probably other jurisdictions that are even higher. And what that means is if you have $1,000 in LFOs and you can't afford to pay them, then when Pierce County sends those on to a collection agency, you now owe either $1,180 or $1,230. You see an immediate increase of a couple $100 in your LFOs. But the county makes no assessment of whether you're willfully refusing to pay. And as we all know, many of the people that go through the criminal justice system are indigent. They can't afford an attorney, they're living paycheck to paycheck, and they can't afford to pay these fees. And so what's happening is people who are poor are receiving additional punishment solely because they're poor. And that's really what it boils down to. We allege that by sanctioning these people, by adding these additional fees without first assessing their ability to pay, Pierce County is violating the constitutions of the United States and Washington. Specifically, we allege that Pierce County is violating the due process and equal protection clauses of the 14th Amendment and the excessive fines clause of the 8th Amendment. And the case has been brought as a proposed class action. We're seeking injunctive and declaratory relief on basically behalf of everyone who owes LFOs in Pierce County and has been sent to collections or may be sent to collections. And really what we want is we just want Pierce County to put a system in place where before it tacks on these additional sanctions, it actually looks at whether a person is willfully failing to pay or is unable to pay. And if they're unable to pay, then they shouldn't have to bear these additional sanctions.
Thank you for describing that. It's such an important case, right? I mean, and this is
Yes.
a way in which people really suffer and really struggle with these legal financial obligations. Can you talk about the role that race equity played in the way you were thinking about this case or the impact that you felt this case might have?
Absolutely. Race equity is an important part of our case. There's no doubt about it. And the reason for that is because we're challenging a systemic practice that really is a part of a larger structure of inequality. Part of what really David spoke to, we've got inequalities just permeating various aspects of society. And so when we step back and we, before we get to the LFO part, if we step back a little bit, we know there are racial disparities in policing and enforcement. As a result of those disparities, we know that Black, Latinx, Indigenous individuals are disproportionately represented in our state's criminal justice system. Because they're disproportionately represented in our criminal justice system, people in these groups are more likely to incur LFOs. And a good example of this is, you just look at some very basic statistics on demographics and census and things like that. In Pierce County, for example, Black individuals are 5.6% of the population. But when it comes to arrests, they make up 17.4% of all arrests. And when it comes to incarceration, they make up 25% of all jail bookings. So 5.6% of the population is a quarter of all jail bookings in Pierce County. That right there shows you the disparate treatment for that group of people. Studies have shown that Black, Latinx, and Indigenous people in Washington are sentenced to LFOs more frequently than white people. They're assessed LFOs at higher rates than white people. So again, we see this sort of rooted in our systems of criminal justice, it's supposed to be, are all of these inequities. And so when you add on top of that, the wealth gap, the income inequality that we see, and the disparities that are rooted in that when it comes to race, for example, Black families make on average 1/3 of what white families make. They're 3 times more likely than white families to be unemployed. And so when we layer that with the disparities in our criminal justice system, the disparities in income inequality, you basically can see that the problems with Pierce County's LFO system are having a huge disparate impact on these communities of color. And so it's interesting. I will say that we don't bring a race discrimination claim directly, but despite that, race equity is something that just underlies the entire case that we're pursuing right now.
I really appreciate you had just explained that so beautifully and so accurately, right? All of these systems are embedded. So we'll come back to you again later, but we haven't heard from Bree yet. So Bree, you're working on another case that awakens a great deal of controversy in this state, the issue of people living unhoused and how our systems treat those people. Can you tell us about the case that you're working on?
Yes, thank you, Michelle. So on behalf of 3 houseless citizens and a taxpayer, we have challenged the city of Seattle's encampment abatement program because the city has violated and continues to violate the rights guaranteed to our houseless clients and other houseless citizens, under the Washington Constitution, in conducting sweeps of homeless encampments. And like David and Toby and Jennifer, I'm gonna step back and provide a little context for this case and this issue. So as we are all aware, Seattle is in the midst of a housing crisis and has been for years. This crisis is a result of soaring housing costs, stagnant wages, cuts to social welfare programs, lack of affordable healthcare, and now the far-reaching effects of the COVID-19 pandemic. And the city hasn't been able to keep up with both the housing and emerging homelessness crisis. Seattle lacks affordable housing and adequate shelter space. And the city's housing crisis has forced thousands of Seattleites out of their homes and unfortunately into homelessness. And many houseless Seattleites have had no choice but to use their vehicles, tents, or even just their sleeping bags on city property to shelter themselves while just trying to survive. One of the city's approaches to addressing the homelessness crisis is its multi-million-dollar encampment abatement program, which is also referred to as sweeps or cleanups of homeless encampments. And the city's program prohibits camping on virtually all public property. The program also requires the training and use of hundreds of police officers to force houseless citizens to leave public property under threat of arrest. And in the process of sweeping encampments under the program, the city routinely seizes and destroys the shelters and belongings of houseless citizens with impunity. The city has repeatedly violated our houseless clients and other houseless citizens' constitutional rights in carrying out these sweeps. And the sweeps do absolutely nothing to solve Seattle's housing and homelessness crisis. And so during these encampment sweeps, our clients have had their tents, medication, medical equipment, important paperwork, clothing they use for work, and tools they use for employment, priceless family heirlooms, and other survival supplies seized by the city and thrown away. And the city does this without a warrant or other authority of law. These sweeps also frequently occurred without any notice to our clients, and often while they are away from their encampment, at a medical appointment or while working. And then they'd return home from working or from their medical appointment to find all of their earthly possessions gone and a simple notice from the city saying that their property had not been stored, but had been in fact thrown away. And our houseless clients have also been repeatedly threatened by law enforcement with arrest during these sweeps, and that would be arrest for criminal trespass, among other things, because they're just simply trying to survive somewhere. And the city's encampment abatement program may abate encampments, but it only does so temporarily because our citizens will continue to experience homelessness as long as Seattle's housing crisis exists. The city has spent more than $10 million a year to administer the sweeps program since 2017. And so by comparison, for the millions of dollars the city has spent on this program, which does nothing to address the real crisis we're all dealing with, it could have housed nearly all of King County's houseless citizens. And like all people, houseless individuals still need to do what is necessary to survive. And in this case, and in the case of our clients, that includes sleeping and sheltering themselves from the elements on city-owned property. Without sufficient, affordable, and shelter housing, houseless citizens have no choice but to try and survive outside on public property. And now, as a result of the city's unconstitutional sweeps program, they have to do so without life-saving medication, clothing necessary for employment, or even blankets to keep themselves warm. Now, in this case, we do understand that the city must make tough decisions in addressing the housing crisis, but the Constitution and the rights that it guarantees to each of our citizens, whether houseless or housed, does not disappear during a crisis. And so we brought 3 claims. And the first one is under Article 1, Section 7 of the Washington Constitution, which prohibits the city from disturbing our private affairs or invading our homes without authority of law. So when the city seized and destroyed our houseless clients' shelters and property without authority of law, they didn't have a warrant, they didn't have anything. The city disturbed our clients' private affairs and invaded their only source of privacy, which violates the Washington Constitution. We've also brought a claim under Article 3, Section 14 of the Washington Constitution, which prohibits the government's cruel punishment, meaning the government can't punish us for acts or conditions that are necessary for survival and conditions that can't be avoided due to circumstances beyond our control, like the housing crisis. And the city, in this case, has effectively criminalized homelessness and living on city-owned property despite a severe lack of available shelter in Seattle and the region. And so this violates Article 1, Section 14 of the Constitution. We've also brought a conversion claim against the city based on all of the property the city seized and then subsequently destroyed that belonged to our clients. So our case is ongoing and it's currently in the discovery phase. We hope this case will not only achieve the results our houseless clients want and make them whole, but ensure the city doesn't violate the constitutional rights of our houseless citizens in the future.
Thank you so much for that explanation. All of these cases we've talked about today are just really heartbreaking at basis, right? People in sort of their worst moments having to deal with violations of their rights. Bree, can you say more about how you all have thought about race equity with regard to this case, how it's played into any of your thinking or strategy or anything?
Yeah, so race equity plays a large role in our sweeps case because the majority of citizens experiencing homelessness in Seattle are people of color, including some of our clients. The systemic issues of racial inequality and the policies that drive that inequity continue to be present in our public and private institutions and have led directly to the disproportionate number of homeless people of color. And these disparities in our public and private institutions manifest themselves in many different ways, from educational attainment to life expectancy, access to healthcare and affordable housing, and access to job training and job opportunities. And the lasting impacts of the systemic and structural racism that are present in all of these areas have led directly to the disproportionate number of people of color experiencing homelessness, both in Seattle and across the country. And the data really reflects how disproportionately certain groups of people of color are affected by homelessness. So based on the data collected in the 2020 point in time count, African Americans represent 7% of the population in King County, but over 25% of the houseless population. Hispanic or Latino individuals make up about 10% of the overall population in King County, but constitute over 15% of the houseless population. And my community, American Indians and Alaska Natives, are less than 1% of the population in King County, but as of 2020, make up more than 15% of the houseless population. And while the city and other regional authorities have promised, in response to this really disturbing data, that they are committed to addressing the causes and consequences of structural racism, and how that leads to homelessness, we can't stand by and wait for the city to, enact equitable and anti-racist housing and education and other policies while it violates the constitutional rights of our houseless citizens, and through a short-sighted program, like sweeps and encampment abatements. And just like Toby observed about the impact of LFOs, given that people of color disproportionately make up the houseless population in Seattle and King County, the city sweeps program disproportionately violates the constitutional rights of houseless people of color. So race equity has played a large role. And while we haven't brought, a direct discrimination claim, this is something that we're very cognizant of. And, one of the reasons, why I wanted to work on this case is because, the majority of houseless people are people of color, and in particular, Native Americans and Alaska Natives.
Thank you for making that so plain and so clear, right? The importance of that. David, I want to come back to you, because when we think about the work that we do on behalf of communities, we also think about the fact that we have to do that work with those communities. You described how quickly this case came about as just a rapid response to these incidents that were occurring at protests. And I'd love to know have you go into more detail about how you went about developing the facts and the legal theories. And in particular, you were working with activists on the ground as well in developing this. Black Lives Matter, Seattle King County is one of the lead plaintiffs. So talk about all of that.
Yeah, we were building this airplane as it took off. It was, like I said, I texted Professor Chang on Friday, and we had the kind of group call with the ACLU, Perkins Coie, and Korematsu Center on Sunday at 11 a.m. Sunday at 11 a.m., we didn't have a complaint, we didn't have claims, we didn't have clients, that was one of the questions in the agenda. I don't think I'm revealing privileged information here, is who's going to be our client? And, we had to resort to some creative approaches. It wasn't like we can invite some folks into a conference room because of COVID. We had to pull, much of our evidence was coming from social media, folks who were posting videos. And so we began reaching out to people. We noticed you posted this video. Is that you in that video? We noticed you made this post. Is that you? We also posted ourselves on social media. Please reach out to us if you were witness to this, if you were witness to that, if you've been harmed. And then someone in the group, I'm actually 95% sure it was, someone at the ACLU, was either Molly or Lisa, Molly is a former staff attorney and Lisa's a current staff attorney at the ACLU, had a relationship with Black Lives Matter King County, and we reached out to them to gauge whether they'd be interested in participating. And that was a discussion that was had, and they decided, very heroically, yeah, we would like to put our name on that. But, several other individuals very heroically, courageously decided, yeah, despite being targeted by the police, we will put our names on this lawsuit, even though it means we might be further targeted by the police. But the mechanics that went into that, I mean, we had, I believe, 6 or 7 individual plaintiffs in Black Lives Matter. When we filed our TRO, submitted something in the order of 24 declarations. We interviewed easily double that. So over the course of Sunday night, Monday, Saturday, because we began interviewing folks even before we met, that was a lot of just one-on-one in each of these interviews. Who is this person? What was the nature of your involvement? Do you have photographic evidence? Because we needed to show the court. We couldn't just rely on allegations. Show the court what's happening to folks. And in many cases, instances, this was graphic. This was almost, violence on a level that you might see on a battlefield. Folks giving us photos of their abdomen discolored, sensitive portions of their body. We had testimony from folks that their genitalia was injured, their faces, an eye was injured. A woman died 3 times. By definition, her heart stopped 3 times because she was shot in the chest at close range with what the police called a foam-tipped projectile, but it's a rubber bullet. And Judge Jones actually called the city out on this at the hearing, where they were downplaying, these are foam tipped. They got a foam tip. And he said, did you get so-and-so's declaration? And they said, yeah. I want you to bring up so-and-so's declaration. Did you see this photo? It's like, yeah, that's what happens when you get hit by one of these things? Okay. And the judge was making a point that, you shouldn't use these euphemisms to describe what are weapons, that you're firing into a crowd of human beings that are made out of flesh and blood and aren't wearing armor. But when we convened, the facts were changing. That Sunday, we were afraid of tear gas being used again. There were reports we felt not credible, but still reports of terrorist-related activity, of bombs, that the DHS might be coming in. Recall that we still had President Trump in office, and there were reports that the federal officials might be coming in. So, the facts were just constantly changing. We were putting the plane together, and then finally it came to, who are we going to sue? Are we going to sue obviously we got to sue the city. Are we also going to sue the chief of police in her official capacity? Back then it was Carmen Best. Are we also going to sue Jenny Durkin as mayor in her official capacity? We decided not to, but we would have if it was strategically important. We decided to just focus on one defendant, the city of Seattle, because in our view, that covered all of them. And it didn't matter to us that, if someone lower in the city, contradicted the mayor's orders. What mattered to us was the city, whether speaking through the chief or speaking through the mayor or speaking through a lieutenant, said they wouldn't use tear gas. And the city, whether acting through a police officer or acting through the mayor or acting through a deputy mayor, used tear gas. And that's what mattered to us. And so we sued the city writ large, and we wanted an order very specific to the city writ large that you have to stop, whether it's an officer or someone acting on behalf of an officer. You can't do this to the crowds. And then it came to the claims. What claims are we going to file? Obviously, Fourth Amendment. We think there was a debate, and I won't go into the privilege communication, but there was a healthy debate here. What is the First Amendment claim? These are hard to make and hard to win. First Amendment claims. It seems like it's simple, but it's not. The First Amendment is a tricky concept. But we didn't just include the First Amendment. We ended up leading with the First Amendment, which is, to our knowledge, still the only case that led with the First Amendment. We felt, of course, the force is excessive. Of course, this is a violation of Fourth Amendment rights. But we think, in fact, the force is so so excessive. It's actually excessive because they're targeting the message. And we were very surprised that Judge Jones agreed. In his order, he agreed that there is substantial evidence here that you are in fact targeting the message, that you're disproportionate, throwing blast balls like they were beads at Mardi Gras, throwing, canisters of tear gas like it was cotton candy. The sheer disproportionality can only lead to one conclusion, which was you were angry about what they were saying. And what they were saying was a message that's protected under the First Amendment, and that's wrong. It was just a strategic choice, but I'm glad we led with it because I think it sort of highlighted the message that needed to be said.
Thank you. I really appreciate that explanation, and many amazing people, right, shared their stories, and that was powerful.
Lisa at the ACLU had like this spreadsheet of witnesses that were reaching out, and Molly and Lisa were going through vetting people, interviewing people, scheduling interviews. And I remember we'd be going back and forth on drafts, and it's 11:45 p.m., not a.m. And Lisa or Molly was like, all right, I'm going to turn over the draft because I got to hop on this witness interview. And, because witnesses, when they're available, they're available. We were interviewing folks around midnight sometimes. Journalists were reaching out to us because often these, the proverbial, hitting the fan would occur right around 11 p.m., 10 p.m. and last through 1 a.m. We submitted so many. We had to resort to non-typical sources of evidence, which was Twitter. And we submitted so many Twitter videos that obviously raises authenticity issues, but the judge went with it. And the city knew that authenticity would be a lame objection at this posture. But the judge did at one point say, I can only access Twitter on my iPad, so please submit it in this particular way. I'm like, sure, judge. We didn't know you had a Twitter handle, but you got it, man. We will send you Twitter links however you'd like, Judge Jones, as long as you will watch the videos we're sending you.
That's great. Toby, coming back to the case about legal financial obligations, you described really well what the problem was and what some of the arguments were or claims that you were making. Is there a point in the case that you actually began to sort of flesh out the race equity issues and put them in consideration?
Yeah, race equity was a consideration at the outset, a reason that we were bringing this case, even though, as I mentioned, we knew that we wouldn't have a race discrimination claim directly. And someone in the audience asked what factored into that decision not to bring a race discrimination claim. And I would say that there were really two reasons. The first is that the law that's developed around this area, really Bearden versus Bearden versus Georgia is the key case from the United States Supreme Court from the 80s. And the focus is not on race, the focus is really on income status and how you deal with people who are poor in certain situations in our criminal justice system. And it's not a protected class, people who are poor, but it's become sort of a quasi-protected class through this line of cases. And so first of all, we knew that that was sort of going to be the root of our claims, at least with respect to the 14th Amendment. And so race is not a part of that. And then the second aspect of it, I would say, is that it starts to create some complications. So our goal here really is to undo this system that's been put into place so that it has great effects, including for people of color and people who are white, people who are poor, whatever their race is. And if we focus just on race discrimination, now we're limiting it to a particular race group. And if we're going to do one race group, we have to have a plaintiff for that race group. And if we're going to try and do another race group, we have to have a plaintiff for that group. And it really sort of complicates the case. So whether that's right or wrong, I think, one can debate that. But strategically, our thought was we're going to have a better chance of undoing the system that is resulting in this inequality across the board if we take it on this particular way, which is why we did it that way. But nevertheless, race equity, again, it's part of personally why I'm interested in these cases, because I want to make a difference. And so right away, we knew we wanted to build that context into the story. And so, we were searching out statistics. There's been some wonderful studies done by the University of Washington and a couple of professors there with regard to LFOs and the racial aspects of that. We started to put these things into our complaint before we even had a plaintiff. So we started to draft the complaint up and build that context of the story in there. And then, we're still early in the case, but we're trying to weave that into our briefing as well. And I think it's important because, this context, as David said earlier on today, it's got to be a part of the conversation, or maybe it was you, Michelle, but, we need to understand as attorneys, as judges, as the public, why there's a problem with these systems. And the reason there's a problem with these systems in large part is because of the race inequity that results from these systems. And so, again, even though the judge isn't going to be directly addressing race as an element of a claim, the judge needs to understand where this is coming from. And I would say that, we all know as lawyers, context often moves the needle a little bit. So the context might not be a specific element of the claim that you're pursuing, but the context is going to have some sort of impact on how the judge views that element of the claim or how the judge applies a particular standard in your case. And so I think the context is something we have to keep front and center. Ultimately, our client, Eddie Lamont, a wonderful gentleman who's in his 50s, he's a military veteran, he's Black. And so his case becomes now a very specific example of the general things that we're putting into context. And so we're doing our best to put forward his specific story at every opportunity. It's in the complaint. We put it into our briefs when we're briefing things before the court. And so I would say that overall, this case is a really good example of how race equity can be advanced through challenges to systems and structures that create inequity, even if you're not directly bringing race discrimination claims or other race-based claims.
So important, right? Because race discrimination is a particular tool. It's a particular type of case that you can bring, and they're important and they need to be brought. But what I think all of you are talking about, again, is, as you've said, Toby, emphasizing this broader context in which our legal system operates, in which some people are just consistently disadvantaged because of the history of our country and the context of everything that has followed from there. And that's a big piece of the message, right? And why we think about how we tell these stories, what legal strategies we choose, and how we proceed in these cases. I want to come back to Jennifer, because for a couple of reasons, and one will involve answering the question that popped up in the chat earlier. So there was, in addition to the litigation that you were a part of, I know you're aware that there was a lot of advocacy on the ground, right? There were activists out there after this kind of got into the news and the consciousness of the community. There were people who were coming out to that intermodal station and handing out Know Your Rights materials. There were activists in the city who were working to get an immigration ordinance passed with the city council in Spokane. So many things were happening. I'm wondering if you have a feeling about how this impacted the litigation, or how all those strategies work together. And then please tell us what the outcome was.
Of course. So I'm a litigator. So my hammer is the lawsuit, right? Or my hammer makes everything look like a lawsuit. But I think when you're dealing with these really systemic issues, you can't just rely on the courts. You have to go through and find all the avenues because it's a hard problem. It's one that requires policy, it requires activism, it requires getting people on the ground to know their rights. As you mentioned earlier, Michelle, one of our clients actually had a Know Your Rights card that he showed to the Border Patrol agents, and they laughed at him. And it's emphasizing, no, these really are your rights. You need to stand up for them. You need to realize they are not allowed to detain and question you just because they want to. So I think getting that out there in the community, especially with folks in Spokane being so concerned about this issue and what can we do about it, kind of helped drove energy. I know from my perspective, working on the lawsuits, it was great to know that I was part of something bigger, that we were all working towards this common goal of getting the government to stop doing this, to stop detaining people just because they're brown. And so what actually ended up happening was we filed both lawsuits. I think they were about a year apart, engaged in a lot of discovery. And at one point, in about January 2020, it turns out that a Border Patrol memo went out that came from one of the agency heads that kind of reemphasized that you actually need permission from a bus company or bus driver to actually get on the bus. You can't, and you can't detain people without reasonable suspicion reminder. So that memo, I think, probably helped. And then, following that, the pandemic then would change the circumstances as well, because people weren't traveling as much through these methods. And my understanding is that the activities have died down for the most part in Spokane. But while all that was going on, yeah, activists were out there making sure people knew what they were allowed to do and what they weren't allowed to do, the agents. Activists were out there lobbying the city council, who was also outraged. They did pass an ordinance in October 2018 banning the patrol agents from trespassing in non-public areas without permission. There are some particular politics there involving the mayor and being able to get permission from the mayor, but the efforts were there, the motivation was there, the energy was there, and all of that, I think, was necessary to really try to even start tackling all this.
And for your clients?
Oh, right. So one of the cases got through summary judgment, and then the other case had been partway through discovery when the government reached out to discuss mediation. And so we actually were able to successfully mediate both cases and come away with a settlement amount that the clients were very happy with. That I think, I think it's hard to say that you can ever get rid of the sort of trauma of being told that you have to go with a uniformed, armed Border Patrol agent who you can tell is singling you out and doesn't really like you. You don't know if you're going to be taken away and put in a jail for 3 months so that you can't see your family, can't even get word to them. You don't know what's going to happen. And in one of our clients' cases, he thought he was doing everything right. He had his work authorization, he had a driver's license that you can only get if you're authorized to be in the United States. And still they, even having the paperwork from the government said, nope, better come with us. So they were, it's hard to really, I think, be able to get over that sort of pain and that the damage and harm that the government did, but we were able to settle the cases.
And obviously, as people, well, I was going to say as the world opens back up, but it's kind of opening and then closing, and then who knows, we're always going to continue to keep an eye on it, right? I mean, someone high up in the agency has said, hey, you're not supposed to do it that way, but we'll be keeping an eye on it, right?
Absolutely.
So there's something that I want to address to everyone, but I'm going to start with Bree. But here it is. You all remember that our state Supreme Court back in June 4th, last summer, 2020, put out a statement, and it was in response also to all the protests that were happening. It was in response to the murder of George Floyd. And they said in the statement, I'm just going to read a small piece of it, the devaluation and degradation of Black lives is not a recent event. It is a persistent and systemic injustice that predates our nation's founding. Recent events have brought to the forefront of our collective consciousness a painful fact that is for too many of our citizens common knowledge. The injustices faced by Black Americans are not relics of the past. We continue to see racialized policing and the overrepresentation of Black Americans in every stage of our criminal and juvenile justice systems. Our institutions remain affected by the vestiges of slavery, Jim Crow laws that were never dismantled, and racist court decisions that were never disavowed. The legal community must recognize that we all bear responsibility for this ongoing injustice and that we are capable of taking steps to address it if only we have the courage and the will. The injustice still plaguing our country has its roots in the individual and collective actions of many, and it cannot be addressed without the individual and collective actions of us all. This was a powerful call to action to address racial inequity in the law and the justice system put out by our state Supreme Court. And so what I wanted to address to each of you, as I said, starting with Bree, what in your view is the role of attorneys in addressing racial injustice? What does it mean about our work? And take it wherever you want to take it. Go ahead, Bree.
So fighting racial injustice is why I wanted to become a lawyer in the first place. As you mentioned at the outset, I am a tribal citizen. I'm an enrolled member of the Seminole Nation of Oklahoma, and I have spent my legal career advocating for tribal clients in a legal system that was originally designed to persecute us. The treatment of Indigenous people under the law, perfectly illustrates how the legal system was, can, and is still used to facilitate structural racism and inequality. The United States has spent the majority of the past 2 centuries waging a campaign of genocide and ethicide against my community, and vital to the United States efforts was its intentional use of our legal and political systems as weapons of colonization and oppression to deprive Indigenous peoples of our homelands, our authority, our resources, our cultures, and even our children. And the lasting effects of these policies, laws, and inequities remain with us in the form of systemic racism, particularly as applied to my community. As I talked about earlier, disproportionate homelessness among Native people is one of those impacts. As Toby mentioned in the context of LFOs, and as I've experienced with some of my tribal clients who have those same LFO issues, disproportionate criminal consequences for Native people in state court is another one of those long-lasting systemic impacts. As David discussed and I've experienced with tribal clients and their families, disproportionate policing and the use of force, and in particular deadly force against Native people, is one of those impacts. And throughout my experience as a clerk, a private practitioner, a legal aid attorney, and a public defender in tribal, state, and federal courts, I have witnessed the unfortunate legacy of racism, in our legal systems. But I have also had the opportunity to wield the law to undo that legacy, and whether, that's in cases, challenging, the government's acts when it comes to tribes, or like the sweeps case, which while there is no, direct racial discrimination claim, it's an issue that disproportionately affects people of color and my community in particular. And I've also had the, opportunity to do that with ACLU in other ways. And I believe as attorneys, we have an ethical duty to ensure that our legal system is just and equitable for all people. We have an ethical duty to fight racial injustice and dismantle those racist systems, that are present and prevalent throughout our legal justice system. And we have not yet achieved a fair and equitable legal system. But, the work that was discussed today by everybody on the panel, and a lot of the work the ACLU does, brings us a lot closer to that kind of justice system.
Thank you so much. It's so eloquent and so spot on. Toby, I'd love to have your reflections on this as well.
Yeah, thank you, Michelle. The law is such an important part of the structure of our society and our culture. We as attorneys are very privileged to have the skills to navigate that. And I agree wholeheartedly with Bree that I think we have an ethical obligation to do whatever we can to ensure that the system becomes more just, because it's currently not there. And there's a lot of work that needs to be done to get there. And so, when it comes to what we can do, I think litigation is just one part of it. I think our skills are an important part of advocacy, more generally, policy, for example, making. There are, things that we can do in our own personal lives. There are things we can do in our own personal firms. I brought a case, it wasn't with the ACLU, but I brought a case recently with Jeff Needle, where we were essentially trying to challenge the jury system of our state, because when it comes down to it, as I discussed, we as a society have all these inequities in terms of income, and the result of that is that a lot of people that live paycheck to paycheck can't afford to serve on juries, and so they don't respond to jury summonses, or they find ways to get out from having to serve. And the statistics and the social studies that go with that are really telling, because it impacts every level. It impacts the person who's on trial, who doesn't see a jury of his peers because he doesn't see anyone that's the same color as him that's deciding his fate. It impacts people that only see our criminal justice system or by going through it as a defendant instead of actually participating as someone that, second to voting. This is the most important part of our democratic society, I think, to make decisions about what's going to happen in a court of law. And unfortunately, we were unsuccessful in that case. It went all the way to the Supreme Court, and we got a negative decision, that basically said this is for the legislature to address. And, our legislature has been not addressing it, despite there being all these task force and other things that say that this is a huge problem. It's the number one problem. The lack of diversity in our juries is the number one problem in our justice system. But the reason I bring it up is because just putting it out there and making it a part of the discussion, the decision came down against us, but if you read it, the court acknowledges that this problem exists, and something needs to be done to deal with it. And so I think, whether it's through litigation with the ACLU on these important cases that we're discussing today, whether it's through going before your legislators and talking to them about these issues and the need for these changes, there's all kinds of different things that we can do. We can bring diversity into our own firms, just all these different things. But I really do feel that we're so privileged to have the skills to help advance this. And I think, again, I just wholeheartedly agree with Bree that we have an ethical obligation to make our system better.
Jennifer, do you have anything to add?
I think Bree and Toby have covered a lot of it. I mean, I think it's the ethical obligation in exchange for this privilege to practice law. I feel that there's an obligation and to give back to the systems, to the communities that are being impacted by the legal system. and to be able to use those skills, to be able to teach those skills in terms of, for instance, letting people understand their rights, not just litigation either, like Toby said, because you need lawyers to help draft the ordinances, interpret the statutes. You need lawyers to help actually bring the lawsuits on the statutes that are supposed to protect people. So I think there's a lot of roles for attorneys to play and a moral imperative to do so.
You know, all three of you, Bree, Toby, Jennifer, have sort of called out the ethical obligation, and Jennifer, you just said a moral imperative. And I'm just thinking, having been a lawyer for some decades myself, that I don't know that I feel like lawyers have felt that way over time. And so, David, I want you to get a chance to address this also, but I'm curious about any reflections you, David, or any of the rest of you have about what this has meant in terms of the evolution of the practice of law, and whether there is a change in how lawyers see themselves in their role vis-a-vis this question of addressing these long-term systemic inequities that have harmed people of color and Indigenous people since this country's founding. David, go ahead.
Yeah, I mean, maybe I take more of a simplistic view of this. I just think in terms of just problem solving, and there are an awful lot of problems out there, and some of which an engineer is going to be awfully well suited to address. That bridge is broken, or some of which a teacher is going to be well suited to address. This student needs more attention. And then there's just problems that lawyers are just in a unique position to address, but they aren't getting addressed. And there's a menu of them. And, whether it's youth incarceration or, it's a real-time problem, such as, protesters being doused with chemical agents, that often just need someone to put their hand up, roll up their sleeves, and get to work. And, you'd be surprised how many problems just linger year after year and then become institutionalized because no one raised their hand, rolled up their sleeve, and got to work. And sometimes it's a matter of how many people are raising their hand, rolling up their sleeves, and getting to work, and we need more. I think in terms of, say, different contexts, voting rights in Washington, for many years, we saw year after year the Latino population in Washington grow dramatically, and year after year the political representation fell, but it certainly remained static. Just as the population was getting bigger, their political representation is getting more and more disproportionately unrepresentative. And, this was not a new problem. This was not an unknown problem. Many people knew it. In fact, Whitman students, undergraduate students, 18, 19, 20-year-old adults, but, young adults, researched this year after year at Whitman College, published report after report. The numbers, I mean, it's just math. It's not like it's a debatable concept. It was math. And, it took Joaquin Avila, the Korematsu Center, and I helped with him, and then the ACLU and League of Women Voters to push the Washington Voting Rights Act. But here's a problem that just lingered until people raised their hand, rolled up their sleeves, and got to work. And it took 8 years, but we got it passed. And so I just think, it's very satisfying to resolve problems, very fulfilling to address it. And as lawyers, setting aside ethical obligations, I completely agree with. I think it just, there's a personal satisfaction to being able to address a problem, whether it's, an employment issue for Microsoft that you can address well, and, or it's, a voting rights issue that no one has, homed in on, but just needed some focused attention. And, 8 years later, here we go. So, lawyers are just uniquely positioned to do things that doctors or engineers or other professionals can't. And why waste that?
Indeed, why waste that? So I am going to come back to this thing though. So the Supreme Court put out this message, and do you think, maybe Toby, you would have a thought, have things changed how attorneys see what their role is in stepping up on addressing these long-term injustices?
I think that they have. And I've been at this almost 20 years. I turned 50 this year, so I don't know if I'm starting to, change the way that I view the world. But I see in the attorneys that are coming into the practice right now an understanding and a knowledge that I don't think was as well developed when I came into it 20 years ago, that I don't think was being discussed 40 years ago. Sure, some of these, To Kill a Mockingbird's been around, right, for a while. A very good story there about some racial issues. But what I'm hopeful about is the fact that I'm seeing the discussion being raised. I think the last couple of years in particular have demonstrated that as a country, we're talking more and more about these issues that have been around for hundreds of years, and the problems that have been around for hundreds of years, and the need to continue to address these things. So I'm very optimistic that there is a change, and it's in the right direction, and I'm very hopeful for the future.
Thanks. Yeah, I mean, I guess I partly asked because I think there's a change, and it's a question for me, will we be able to sustain this? It's kind of like when all the protests were happening, and the protests last summer were amazing. They were more multiracial, intergenerational, right, than many of us had ever seen before in any outcries against a particular injustice. And many also felt, let us not lose sight of the fact that even after George Floyd was murdered, even after the verdict went down, right there in Minnesota, another Black person was killed by the police. The problem hasn't ended. And so I really call upon all of us, I think, to wonder how we will individually keep alive that fight for rights, whether it is, as David described, just it was right there in black and white in math that, Latinos were not being represented, in government, or as Bree has observed, the really hideous and long-term, failure to acknowledge treaties, the stolen land, the stolen children, right, that has happened for generations. So there's still much work left to be done. Let me, I want to again remind folks that if you have questions, please feel free to ask them. The best way to do it is through the Q&A box, because it's easier for me to see it there, since a lot of things happen in the chat that aren't necessarily questions. So let me just put this one to you, because we are interested in having people know why it's fun to be a cooperating attorney with the ACLU, right? Would love for each of you to just say, like, why did you want to become a cooperating attorney? And, what's been great about it, if great or hard or good, whatever. So Jennifer, I'll let you go first.
Well, I like to think that in part it's that ethical obligation that we just talked about that kind of motivated me to take up these opportunities. But I mean, ACLU of Washington does really great, amazing work in the state. It's hard to say, like, why wouldn't it's like, why wouldn't you want to work for, why wouldn't you want to be a cooperating attorney? From my perspective, I think like, even aside from moving towards trying to get our society to be more just, right? There's just interesting, engaging problems, right? There's the opportunity to work with these, staff attorneys who are coming from this plaintiff side perspective, which is not necessarily what my clients are usually on the side of when we're talking about captions, and kind of getting a diversity of thoughts about the litigation, about lawsuit, learning so much from super experienced folks who are willing to share that and help me just, personally become a better litigator, let alone one who feels like I'm kind of making a difference and being part of something bigger, like trying to get the government to stop discriminating against people on buses. It's been a great opportunity, and I really enjoy the work I've been able to do and the opportunity to do it.
And it's been absolutely wonderful to have you doing it and appreciate you being on the legal committee as well. Bree, please share about your experience. You've been hanging out with the ACLU for a while.
Yes, I was, first exposed to, ACLU and, a lot of these issues we've talked about today, and, the different staff attorneys and, our visionary legal warriors like Nancy Wallon, legal committee. And then what, really inspired me to get more involved as a cooperating attorney is the fact that the work ACLU does affects real people. So whether it's like the sweeps case that I'm dealing with, or the LFO case that Toby's working on, like I've had lots and lots of clients who've had issues with debilitating and discriminatory like LFOs. And so it's really important to me to do work that affects like real people and will help people like be able to get their driver's license back and like be able to get a job and like take their kids to school and like be able to volunteer on field trips. And part of the reason too is my firm, Kilpatrick Townsend, really supports this kind of meaningful, impactful pro bono work in the community.
And again, we're so grateful for you. David?
Can you hear me now? Yeah, I mean, this has been great. I mean, I think as an attorney, I'm always looking for these types of cases. But one thing I just wanted to highlight, and I don't know if others at firms or with different teams in the ACLU when you guys work with younger attorneys, these cases are excellent ways to train attorneys. These cases tend to have critical issues that you can't quickly settle. Fundamental issues that will require argument or depositions, meat and potatoes, litigation tasks. So, while not directly relevant to the question you asked, I just think it's really, really important to get young attorneys involved in cases like this early, often, and give them substantive roles, not only because it will, typically remind someone why they went to law school, but it can make them better attorneys. It could make you a better, in my case, a better partner supervisor, and just a better mentor generally. Like, these are cases that young attorneys want to work on. Give them the opportunity to work on it. They'll impress you. They'll learn how to be better attorneys, and they'll be there for the next case and the next case and the next case. And suddenly, we have a good, deep bench of experience, whether it's constitutional law attorneys or housing advocates or, police accountability attorneys that are ready to go the next time the case pops up. So I just encourage, folks listening on this call, listening on this CLE, particularly more senior folks, get your teammates, particularly your junior teammates, involved in these cases. They're rewarding, they're enriching, and they're excellent training grounds. And, it's harder to do that on the big institutional clients class action, but these are great ones to do that with.
Actually, that was fully responsive, David, right? I mean, and the partnerships that we have with attorneys and with firms are amazing because it's a resource share in both directions, right? Like we have, when younger people do get involved in the case, right? Like we have people like Nancy and Tony and others who are just experts and just really help. But it's a collaborative thing. It's a mutual thing. And that's one of the things that we really appreciate too, is being engaged with you all in digging into what should be the legal issues here, where, as you were talking about, are we going to lead with First Amendment or something else, right? Like being in those conversations and then taking them out there. And as Bree said, making a difference in people's lives. It's really, it's huge. Toby, you want to say anything about your experience with us? I know we have been so grateful to also work with you over many years.
Yeah, it's been just wonderful. I first started working with the ACLU about 10 years ago. And it was not me going to the ACLU as a cooperating attorney, but we had filed a class action against a couple municipalities here in Washington over Sixth Amendment rights issues. And the legal director at the time, Sarah Dunn, and Nancy Towner reached out right after we filed because in their wisdom, and they were absolutely right, they knew it was going to be a test case and that it was probably going to go really far, and it certainly did. We ultimately did a 9-day trial in front of Judge Lasnik. And so they reached out and they said, we'd love to work with you and help support you. And me and my colleagues were like, great, that's fantastic. What went from there was everything David was saying, not only the opportunity to work with Nancy and Sarah, but the cooperating attorneys that they brought on from Perkins Coie. I got to try the case with James Williams. I learned so much from him. I learned so much from Nancy and Sarah. And so over that experience, when I think the next case was Vanessa Hernandez reaching out about a debtor's prison case against Benton County, I just jumped at the opportunity. I mean, it was a no-brainer because, you get to work with these just wonderful people. You get to learn so much. One thing I would say to those out there that are thinking about this is, even if you're not really steeped in constitutional rights or civil rights, don't let that dissuade you from participating, because you have all the expertise in the ACLU of Washington in those areas, and you're going to learn from them. But there's so much else that you can bring to it. There's so much to do. I just love it. It's why I wanted to become a lawyer. It's impact litigation. Like Bree said, you're helping real people, sometimes thousands and thousands of real people all at once. It's just tremendously rewarding. I can't say anything more than that about it.
Well, and you said something there at the end that I actually was going to follow up with, which is, sometimes attorneys, their practice is in, business law or intellectual property, right? And maybe they feel nervous about doing something that's about civil liberties in the Constitution. And I wonder if any of you have any reflections on how you can make that, how you can translate that. And Jennifer, I am kind of looking at you.
Well, especially I think, to David's point about more junior attorneys, and I feel like I was in that position as well. I was a mid-level associate when I worked on these cases, and was working with a team of, 8 or 10 attorneys at a time involved in the different cases. I think, especially when you're so junior, you're not an IP expert, in your first year of law practice. You're not an employment law expert. You're not, the world's expert on securities fraud. So, I think it's just another area of law to learn, just like every other area of law. And the resources available in the form of these, the staff attorneys like Lisa, who helped us on our case, and Molly as well. And then in our case, also having the really great folks at NERP on board as well. It's an opportunity to learn and get up to speed on the areas of law, to do legal research, just like you do legal research for anything else. And to, go back to, as David said, the reasons you went to law school, the constitutional law classes you took, the thinking about what it is that, is the fundamental, part of this country in terms of what its ideals mean to be, and trying to reach them.
Thank you. Yeah, I love that about what the ideals of our country, the ideals of our legal system, all the things that we've held out as important, all the courthouses that say justice for all across the front of them, right? Where we know that that's not what actually happens, is a huge driving force, and it's a huge opportunity. I think I would ask one more question. I don't see anything else coming in from the audience. And then we'll wrap up, and there's a survey. So please, people, don't leave. We want you to do the survey before you leave. How many of you, with the cases that you've worked on as a cooperating attorney or in collaboration with ACLU, have been cases in which you personally got a chance to meet or develop a relationship with the clients? And if so, what was there an aspect of that that has impacted, your sort of feeling about what you were able to accomplish, or feedback that you got from them about what it meant to be involved in the case, that sort of thing? I think some of you have had that experience.
Yeah, I've had a chance to work directly with several of the clients, and it's really rewarding. You know, you get to meet people from totally different walks of life, and you get to develop really special relationships. It's one of the ones that comes to mind actually. I didn't meet her until the day I was arguing before the Washington Supreme Court because I came into the case really late. But after we were successful, I got to work with her quite a bit just to help her go through sort of the next steps that followed from the case. I still text her and hear from her regularly. And so, you know, I think it's just really rewarding, and it's really special to get to meet people that you wouldn't otherwise get a chance to talk to and get to understand and know.
And I've also had the opportunity to meet some of our houseless clients in the sweeps case. And again, it just reminds me, you know, why I wanted to be an attorney in the first place. I've always been, you know, really passionate about working with individual clients and, you know, learning their stories. And, you know, particularly in the case of houseless people, you know, I really liked hearing from, you know, our clients, like, you know, what could the city do better? What improvements could be made? You know, suggestions from the people who are actually experiencing this as opposed to, you know, a bunch of, you know, people who haven't had that experience, you know, telling houseless people what is best for them. And then, you know, after law school, I worked at a transitional living home for formerly homeless young adults. So again, I feel like I was able to, you know, contribute and, you know, help these issues for real people.
Yeah, in our case, you know, whether it's the BLM case or some voting rights cases we've done working directly with the clients, it really brings home the issues. You know, when someone describes getting shot at by their own police department, it sort of brings home the issue in a way a brief never could. When someone describes the experiences, you know, trying the fear of protesting because they're afraid that their own police will commit violence against them, you know, it lends a degree of importance and urgency to our work, and it's just a very, very different experience than, you know, your typical commercial litigation case. A couple questions earlier though, Michelle, you asked about, you know, we sometimes have different skill sets, whether it's IP, or trade secrets, or you know, employment. You know, as litigators, we're always, or as lawyers generally, we're called on to wear different hats, exercise different muscles, and you'd be surprised that the muscles you exercise litigating a trade secret case will come in really handy when you're negotiating a protective order against the city, you know, because you're dealing with a bunch of confidential information, and you know, these skills are way more transferable, I think, than we give them credit for. And a good attorney, regardless of the background, is worth her weight or his weight in gold.
I think that's really right. And, you know, we have cooperating attorneys who are IP attorneys and trade secret, you know, doing all these different kinds of area, or who are smaller practitioners. And we had a question too from someone who said, you know, I primarily want to do pro bono, but I'm a very new attorney, and I can't get the experience and knowledge that I need. And I would encourage you to fill out the survey that we are very shortly going to post into the chat for everyone here, and let us have an opportunity to learn more about what you're interested in and how we could potentially help you. So, or how you could potentially help us, because, you know, everything isn't about litigation. It is true that as a cooperating attorney, if you don't have any litigation experience, it's harder for us to have you work on that. But we also have the amicus briefs, right? You've learned to do legal research and to write briefs. And as we said earlier, so many of the ways we're able to make a difference, big difference, big impact in the law, and how it operates is through these other briefs. So I would encourage folks to just go ahead and fill out that survey when it gets posted. And in fact, I'm just going to say maybe Elizabeth here on the staff. Okay, there it is. There it is. I was like, please post the survey again. I can't do it. All right, great. So that's in the chat box now. Definitely encourage people to do that. So I am inclined to have us wrap up. And so we do also have a course evaluation we want you to do. Is there anything from any of the panelists that you want to say before I do wrap up? Not mandatory, but if you do, give me a wave or just come off mute and you can get a final word in.
I would just encourage folks to, if you haven't worked with the ACLU before and you're interested in it, don't hesitate. It's just a wonderful experience, and you should take advantage of it. And you can do really good work, the kind of work that you went to law school for.
Yeah, and I would just echo what Toby said. Aside from working on really meaningful issues, all the staff attorneys and staff at ACLU are really cool and like really fun to work with. Like, I know I look forward to all of my meetings, so that's a consideration as well.
Well, I just want to say to all the panelists, thank you for being on the panel and sharing your experiences, because that's amazing. Even more so, thank you for the work that you do on cases with us. And even more so, thank you for the work that you do in your own communities and on all your other litigation and your work. You are all justice-minded people, and we really cherish that. Washington State is an amazing community of lawyers in terms of the pro bono, in terms of the care about access to justice, racial justice, and so many issues. And you all are right in the center of that. And so huge gratitude to you, Toby, Jennifer, Bree, David, for what you do. And I also want to thank our ACLU staff, Elizabeth, Tony, and Nancy in particular, who've been really providing a great deal of support for this CLE series. For all of our former speakers in the series. If y'all think we should do another series next summer, let us know. It's so important to be able to be in these conversations with each other and to try to move the needle forward so that justice is really real for everyone. And as so many people say, and I ascribe to this belief, when you address the needs of the people who are most vulnerable, who have been made to be in most marginalized conditions due to systems of supremacy and oppression and even rule of law, right? When you do that, then we actually make everything better for everyone. So really excited to be in this work with all of you. I want to thank those of you in the audience who've been a part of this for your questions and for your attention. There is an evaluation you will receive either in the chat or by email because you signed up. So with that, I am going to adjourn us. Thank you, thank you.
Thank you, Michelle.
Thank you.
Thank you.